Good morning everyone and welcome to the 24th meeting of the Equalities and Human Rights Committee. Can you please ensure that all mobile devices are switched off and put away? This morning we have apologies from Angela Constance and Alec Cole-Hamilton. Can I welcome Beatrice Wishart as a substitute? Agenda item 1 is Female Genital Mutilation Protection and Guidance Scotland Bill. And we continue with our oral evidence. Can I welcome Andrea Bradley, Assistant Secretary, Education and Equalities, Educational Institute of Scotland, Detective Superintendent Elaine Galbraith, Public Protection Specialist, Crime Division, Police Scotland, Suzanne Hargreaves, Senior Education Officer for Health and Wellbeing, Education Scotland, and Liz Owens, Senior Officer, Child Protection, Glasgow Health and Social Care Partnership on behalf of Social Work Scotland. You're all very welcome this morning. Thanks for being with us. Can I ask you to start off by spending just a few minutes telling us about your experience or knowledge of FGM and the work that you do in relation to that, please? And we'll come to yourself first.
Convener, thank you. So, as explained, my name's Elaine Galbraith. I'm the Head of Child and Adult Protection for Police Scotland, and within that I've got various portfolios, one of them being the Child Protection portfolio. So I have a team that work very closely with the divisions and are responsible for developing our policies and work with other agencies in relation to FGM. That extends to working closely with third sector organisations in particular, in terms of learning more about how the police approach can be developed in time and improvement can be made with regards to how we deal with FGM. So that is an ongoing piece of work. We have attended various events over the course of the years, held a conference at the Scottish Police College a couple of years ago, which was very much centred around enhancing our work with communities. A lot of the groups that we work with were invited to attend. We actually centred the whole day round about survivors' experience in order to, again, better our practice. We combine that with local policing officers who are working in communities, both in terms of the public protection arena and indeed community officers, again, just to try and share that learning. So that kind of summarises my own experience and my own teams.
Thank you for that. Andrea.
So, hi, I'm Andrea Bradley, Assistant Secretary, Education and Equality with the Educational Institute of Scotland, and we are the biggest teacher trade union in Scotland, representing members across nursery, primary and the secondary school sectors. There's obviously a huge kind of aspect of FGM matters which are of professional interest to teachers. Teachers have certain professional responsibilities in relation to child protection, in relation to equality matters. So as a trade union and a professional association representing teachers, we have a particular interest in this area. As a trade union and professional association, we have been long-standing campaigners around various aspects related to gender equality, and we see FGM sitting, very comfortably within that. And obviously any matters that relate to teachers, the professional standards by which teachers are governed is a matter of concern to the EIS as well, and the GTCS professional standards has quite clearly within it a responsibility outlined for teachers where they have a duty to safeguard, protect the well-being interests of young people, and they also have a responsibility to promote and ensure as far as possible that young people are treated equally in their experience of school education. So from all of those aspects, we have a particular interest. In terms of FGM specifically, we haven't had too much sort of dialogue with our members around that. We keep an eye on this area. We don't have a large number of reports from our members of this being a particular concern, but we also think that there's an issue here around professional learning. That's another area that I have responsibility for within the EIS. And what we've got back from members around certain inquiries that we've made in this area is that they feel that they need professional learning that is specific to this aspect, but also more broadly in relation into Equalities. It's a, that's been a kind of long-standing ask of our members, that they have quite systematic, easily available, high-quality professional learning that relates to equality, and we would like to see some specificity around FGM
I think
within that.
We'll certainly get into that a bit later on. Liz.
Okay, morning. Sorry, I'm going to cough. Probably I've got a cough. So my name's Liz Owens. I'm a senior officer with Glasgow's Policy and Practice Team, Central Child Protection Team. And so my experience probably of FGM spans both direct practice and policy development and training. So in terms of practice development, our role is to support best practice. And so for anything in terms of special circumstances, we would be consulted by our social work colleagues in terms of offering advice and guidance and attending child protection case discussions where FGM was a concern, along with partner agencies in terms of police, health and education. So in terms of practice, that's the kind of practice development. Along with the Child Protection Committee and partner agencies, we have developed FGM guidance, certainly in Glasgow, and we obviously have delivered some training, multi-agency training, again with education colleagues, but also with health colleagues. Other experiences around engaging with communities. So we've engaged over the last few years with initially the Black African communities in terms of looking at child protection in its broadest context, but also including some discussion around FGM. And from there, we developed a cultural competence training programme for all staff, multi-agency staff, a one-day training programme looking at actually how culturally competent are we to have really sensitive conversations with communities, and how do we better work with communities actually so that we're not driving FGM and other harmful practices underground. So I think that's probably covers me.
Thank you. Suzanne.
Okay, good morning. I'm Suzanne Hargreaves from Education Scotland, Senior Education Officer for Health and Wellbeing Curriculum. And within the curriculum, we have one of the organisers is relationships, sexual health and parenthood. And within that, we have experiences and outcomes and benchmarks. So I'm here today to talk a little about the work we've done around the curriculum aspect of health and wellbeing. The E's and O's and the benchmarks are progressive and coherent. In respect to FGM, it comes in at third level, which is S1, S2 and 3, and we use that as an example of gender-based violence. The benchmarks were internationally marked to make sure that Scottish children were not out of step in terms of age and stage appropriate aspects of learning. And what we have within the benchmarks is that children from a very young age learn that their body, my body belongs to me, straight through to third and fourth level, where children are learning about the support available, current legislation related to ranges of types of abuse, for example, FGM, domestic abuse, grooming and child sexual exploitation. So we have launched at this year's Scottish Learning Festival a new RSHP resource, which is progressive and coherent all the way through from 3 to 18. And within the resource at third and fourth level, there are lessons around FGM, including lessons about human sexuality and the idea of sexual rights. It's all very well having a resource, but we have a plan. I'm glad that Andrea brought up about professional learning, because on the 29th of October we're about to launch a programme of professional learning for teachers and teachers and practitioners who work with young people, because young people told us they wanted confident and competent teachers around this aspect.
Okay, thank you. That's really helpful. My next question is whether you support the Bill's aims to strengthen the existing legal framework. And it would be helpful to know your general view on the existing framework as well. Who would like to
go first?
Yeah.
Police Scotland does support strengthening the legislation and certain aspects of what's been proposed. Anything that can provide us with more opportunities, first of all, to identify where FGM is occurring, and more importantly, from a policing point of view, to then enforce legislation that will help eradicate FGM. So we wholeheartely support particularly the proposal around FGM prevention orders, seeing that as an obvious tool to try and prevent certain activity and put conditions around individuals that will assist us in terms of trying to enforce legislation. In terms of the current framework, there's probably some limitations with that, and that we have experienced, particularly when it comes to that prevention. I think everybody would agree that prevention is what we want to see. We're not wanting to wait until a child has been abused and then have to enforce legislation. So in terms of any opportunities that there would be to look at any preventative offending legislation, that we would certainly wish to explore that as well.
Obviously, FGM is already illegal. Do you have a view on whether the approaches that are available at the moment are being used fully or not, and why do you think that is?
I think a lot of this comes down to, as I said at the beginning, that under-reporting potentially that is going on. The data, as you know, is very limited in terms of the prevalence of FGM across the country. And as I spoke earlier about discussions that we've had with members of communities, I think there is a fear aspect that is attached to that as well. So then by not identifying that FGM has occurred then makes it very difficult to enforce the legislation that is in place already.
Okay. And what is it about the protection orders that you think will improve that?
Well, first of all, it's a civil order. We've seen other civil orders being used effectively in terms of the conduct of others and that ability to actually put things in place. And I think from individual members of the community's point of view, having that order to say, look, this is, the legislation, yes, says it's illegal. It has said it's illegal for some time, but actually there's an order now that prevents us removing our child from this country, or prevents somebody from coming in or encouraging or coercing parents to remove children from the country, or indeed people coming into the country. It prevents them from carrying out any acts. So I think that added layer of protection is where we certainly see the positives in terms of the bill.
Okay, thank you. Do any other panel members have a view on the...
In terms of Social Work Scotland, yeah, definitely uphold the strengthening of the bill. And I think, like Elaine said, I think for me probably there's a little bit about, we've had really good engagement with communities. We've had some really important conversations, really frank conversations. We've heard from women and children about their experiences, and the order, I think, is something that then would be a real protective and empowering thing to have.
Andrea?
That, where there are currently child protection procedures firmly in place across the school sector, and teachers are confident in the way that they engage with those, there's perhaps a question about 16 and 17-year-olds and how well they're protected currently by the current procedures. I think there's also an opportunity with the strengthening of legislation around this area to educate all of our frontline workers who are working with children and young people around FGM, what it looks like, who might be at particular risk of experiencing it, and what measures can be taken to counteract it across all of our service areas. In terms of statutory guidance, I think it's important for that element to be included, but would say that has to be framed in terms that practitioners can understand, bureaucracy light, in order that teachers don't have to have significant amounts of time spent understanding it, processing it, etc. But I would also reiterate the point that I made earlier, and that Suzanne has echoed, around professional learning and the importance of that being attached to anything that we do in this area. I think as a society, Scotland as a society, I think that we would want to absolutely do all that we practicably can to safeguard the well-being, the personal safety, the physical safety and psychological safety of all of our children and young people, and particularly girls who would be vulnerable to that kind of abuse.
You answered my next question without me asking it, which was good, which is around some of the evidence we'd heard that gap for 16 and 17-year-olds. I wonder if other panel members have any reflections on that.
current child protection procedures do go up to the age of 18, but your legislative opportunities to offer protection stop if you're just coming into a system at 16 and 17. And for some experience around forced marriage, it's been 16 and 17-year-olds, so that's been great. We've been able to use forced marriage orders successfully. So again, I think that there needs to be a greater focus on 16 and 17-year-olds, and we need to hold them kind of within our child protection processes, as well as thinking about going for a forced marriage protection order. So I think it would be very, very useful to have that.
Thank you. Okay, Beatrice.
I was going to ask what your views were on the FGM protection orders, but I think you've probably answered quite a bit of that. I was particularly interested in finding out what could be done for women and girls, how we can protect them if they're taken out of the country and then brought back again, how the FGM protection orders might help them. Do you have any thoughts on that?
I'll go again if that's so. Yeah, I think when it comes to the travel aspect, obviously has been a huge factor in terms of FGM, and certainly some of the conditions that may be looked at is round about preventing that travel occurring in the first instance. A lot of the discussions that take place multi-agency in relation to individual concerns are from the likes of education, where there is a planned trip, and it's quite difficult because you don't have anything other than there's an indication, and then looking at other risk factors. Is that child potentially at risk of significant harm? It's very, very difficult to then make that assessment just based on the fact that there is the planned trip. However, by having the protection order, by looking at it through that risk assessment framework, by then having that multi-agency discussion and that through IRD and saying, actually, I think there is merit here in trying to prevent the child going out of the country in the first instance. And the best means of doing that is in terms of the protection at the border. So that would be one aspect of in terms of the travel.
Okay. Any other thoughts from the rest?
I think again there's an interplay between the child protection processes that we have just now in terms of child protection orders, and whether there's a discussion to be had at the IRD stage with our partner agencies about whether we go for a child protection order if we have immediate risk that day, and then we consider the application for a forced marriage protection order. I think, again, drawing a parallel to forced marriage, we've successfully, through our initial referral discussions and case discussions, considered whether we needed to have an application ready and sitting and waiting, and flagged it obviously at ports and airports. So again, I think there's practice there that we can draw on. It's not a huge significant amount for us in Scotland, but there is practice there for us to think about how we would look at our statutory guidance and what we would guide people to do actually in practice situations.
Thank you. Can I ask? Yeah. Another question. Why do you think there's been no prosecutions in Scotland?
The identification and underreporting and the sufficiency of evidence really is where this comes down to. I mean, there's obviously been one UK-wide, but in terms of Scotland, from what we hear and from what we're looking at in terms of the concerns that come forward and then how these are then processed, you know, everyone is, as Liz says, where there is a significant concern will go through child protection procedures, and we hold this as part of child protection. So there is that multi-agency assessment, information sharing and decision making that then goes on, and if there is a need to investigate further, then that is undertaken either jointly or single agency. But I think what then comes out of that is that there is, whether it's through fear or people not wishing to speak up within communities, there is that lack of evidence that is required for a criminal case.
Okay. Thank you.
Okay, Oliver.
Thank you, convener. Just following on really on that point on criminalisation, how do you feel about FGM protection orders and the breach of them being criminalised?
Again, I think it sends such a strong message in terms of that the breach of the order would be then a criminal offence. I think that for me, in terms of getting the order in the first place and then policing it if any of the conditions are broken, will go a long way to outlining that Scotland very much sees that any association with FGM is a criminal offence.
I guess it's not my view, but I'm just putting the point to you. If we're saying that the current legislation is kind of difficult to use because people are fearful that it will lead to criminalisation, do you think there's any risk that they'll kind of confuse the criminalisation of a breach of an FGM order with that legislation, and it will change how they think about FGM protection orders?
No, I think the protection orders will be seen as a protective measure and something that I think the word was used earlier, empowerment. You know, that they have this, and that can then you know, takes that responsibility in terms of you know, from a survivor or victim's point of view, it all being on them. The protection order then comes in terms of being able to prevent FGM occurring in the first place. So no, I think I only see it being a good thing, to be perfectly honest.
That's very helpful. In terms of any breach, do you have a view on what the penalty should be if an order is breached?
Similar to what we've seen in terms of the forced marriage protection orders would be my own view.
Does anyone else have a view on that? Am I allowed to ask a leader?
Same in terms of the penalty for breach. I think there are already, there's already change and really important conversations happening in communities for women and girls talking about FGM and wanting the practice to change. So I think the forced marriage, I think the criminalisation would strengthen that position actually and help sustain that change or progress that change.
Thank you. And then my sort of other question would just be whether you have a view on children's hearings being able to grant an FGM protection order, and if so, why?
That's a big question.
Sorry.
I suppose I haven't considered children's hearing obviously being able to grant the order. It would make it easier if we were going for a child protection order and then we're in that process for under 16-year-olds. I'm not sure how that would actually happen, to be honest, but how that would be done.
Can I ask how you think that would be for the girl and family involved? Do you think that there would be a difference if it was?
I think it's a different process, isn't it? And actually, I think the court process could be much more sensitively managed in terms of potential special measures, whereas a children's hearing process can be quite adversarial and quite a difficult process to be involved in, and people would be given all that information. So I'm not sure that the skills on a personal level, I'm not sure about Social Work Scotland, but I'm not sure how skilled people would be in managing such sensitive information at times.
It's interesting, thank you.
Thank you very much.
You wanted to?
Thanks. It's really just a brief supplementary on Oliver Mundell's line of questioning there. We've heard some mixed evidence from panels previously around the issue of criminalisation, and I think that the general principles that you've described today, most folk would agree with. It sends out a clear message, but there's also a worry that it could put the practice even further underground, if you like. Have you got any thoughts on that aspect of the criminalisation?
I think the point that Suzanne made about curriculum is important, and Elaine's point about underreporting. I think there's a job to be done in terms of raising young people's awareness of their rights as young people, you know, their rights to protection, safety, security, all of that. I think that's a bit of, you know, of all of this picture that needs to be kept strongly in mind, so that, you know, when we're considering introducing legislation which may have the unintended consequences of you know, greater underreporting than we're already seeing, we maybe need to kind of be conscious of that risk, but counteract that with skilling up young people themselves in terms of their understanding of the issues and their rights and entitlements as human beings. You know, a strongly kind of human rights approach to all of this within the school curriculum. But again, I would make a plea around time and space for teachers to consider all that and create the time and space within the curriculum to address those very, you know, complex and quite sensitive areas.
Has anybody else got a view on the?
Yeah, I would agree with that. I also think it's really important that we think about our engaging with communities and public awareness and actually having those very public conversations and thinking with communities about actually how do we change that. We do need to talk about criminalisation, we do need to talk about the protection of children, we do need to talk about the law and our duty to protect children. This is a form of abuse, so it should be no different from any other form of abuse. But we do need to be engaging with communities and having those conversations with faith leaders, communities across the board, mothers and fathers, grandparents, as well as doing all the really vital work with children and young people.
Yeah, thanks a lot for that. What started off as a supplementary has actually taken me on quite nicely to my own line of questioning. And so when you're talking about that issue there of education, if you like, in raising awareness, do you think we need to be raising awareness of FGM right across Scotland through every group in every part of Scottish society, or do you think it should be targeted, if you like?
So I think you probably need to do both. I think you need to do general public awareness. I think in terms of having done some engaging with communities around child protection, I think it's important not to label, obviously done a lot of work on CSE and sitting in a national working group as well as the FGM implementation action plan group. But I think it's important when we're talking about child protection, we talk about child protection generally, and then we include that in that conversation. So it's another form of abuse. That would be my view there.
Yeah, I think that's a really good point, because we have also heard evidence about real concerns and worries about possible racial profiling in relation to targeting. So it's interesting to hear your response to.
Yeah, I would agree in terms of the universal and targeted. This new resource that's just been launched doesn't shy away with all the issues that young people face in the 21st century, including unprecedented access to porn. So the resource is being built with that in mind. We piloted 38 schools where young people were working with the resource, and young people have been hugely influential in designing the resource. And I do think we need to be careful about how we look at things like gender-based violence, because the curriculum is designed to meet the needs of the children in front of you. So teachers and schools will decide what's the most appropriate aspects of RSHP for children to learn, and it might be that FGM is one of them under gender-based violence.
But that approach would be rolled out, if you like, to all children, you know, going through the curriculum. Yes. Yeah. Yes. Okay, thanks very much. That was another area of question. I suppose the other thing that I wanted to ask to finish off, convener, was about training more generally for each of your services. I wonder if you're each able to say very briefly what sort of, I know you all touched on it in your opening statement, so you don't need to go much further than that, but what sort of training your services have had, and what plans are in place for future training? As I say, I know some of the panellists have already mentioned that.
So from a policing point of view, FGM is part of the child protection standing operating procedure. It also sits within its own standing operating procedure as well, alongside honour-based abuse and forced marriage. Currently, we're undergoing a process of review of all our standing operating procedures in terms of making them more accessible and applicable to all 23,000 police officers and staff across Police Scotland. But in addition to that, there is also specific training inputs that are given through the Scottish Police College, as well as localised multi-agency training that I'm aware that occurs as well. So for the likes of my own area of business in terms of public protection, there are inputs into the Investigators Development Programme, which is the detective officers training, the various stages of that, right the way up to senior investigating officer. Specific inputs on the investigation of FGM. Additionally, within child protection, we have a separate child protection course for those officers coming into that specialism, and there is a lesson in relation to that. And probably the most important is our interagency referral discussion course, a 3-day course that we have at the college. Again, where this is to assist officers who are undertaking that role, dealing with multi-agency partners in NHS and social work, how they then make the decisions when information comes in, because obviously that is the critical point in terms of how we go forward. So it's safe to say that it's universally available in terms of our intranet, the standing operating procedures and guidance and information in relation to FGM, but specific, bespoke and concentrated training for those that are going to be working in this area.
Okay, thanks.
Teachers, it would appear to be some teachers in some schools and some local authorities have some exposure to FGM training, usually within the package of training that they receive in relation to child protection more generally. We asked a question about confidence levels of teachers in relation to handling potential cases as they might emerge, and again that was a very mixed response that we got. Some people saying yep, confident, I would know how to to channel that through child protection procedures. Others saying not confident at all, please could we have some guidance in this area, even although the teachers that we asked reported that this was not something that they were coming across at all. Maybe some anecdotal references, people had some anecdotal experience of it, but not anything really very specific. So our impression is that it's very kind of patchy. Local authorities are taking different responses to it. We know of one local authority that looks to have included it quite systematically within a child protection online training package that they've just recently adapted. But it seems to be that there's maybe a dearth of that. And your point, Fulton, about racial profiling is one that we would consider to be important as well. It needs to be really quite carefully thought out, not just how we would skill teachers up in relation to FGM, but how we would do it in a way that would avoid exactly that scenario, because we know about the way that, for example, the prevent duty and the training around that has been rolled out south of the border, and that has resulted in some really unfortunate cases of children and their families falling foul of misjudgment around matters related to extremism, of a variety of kinds. So I think that training needs to be systematic across the country. Statutory guidance in that regard would be helpful, and we need to take really careful consideration of that element around potential racial profiling.
Yeah,
Just that, what your view is on the benefit of making the guidance statutory rather than advisory. Can you just speak to that a little bit?
Well, there currently is guidance which is there in an advisory capacity, and our teachers are telling us that this is not high in their consciousnesses, and that they don't feel confident in addressing the issue. So maybe some strengthening around the status of that guidance would maybe generate a bit of activity within the system to improve that picture. That said, I'm also very conscious about the number of asks that there are to the education service, and the amount of strain that there currently is in relation to teacher workload, the number of training demands, professional learning demands. But it's maybe about decluttering some of the other elements that don't really required to be there, and deciding on what's absolutely a priority. And I think that something like this that is about the safety of children and young people, girls and young women in particular, there's some space has to be created in the system for that.
Thank you, that's really helpful. Do any other panel members have any views on guidance for practitioners?
Again, I would concur that it would strengthen and support the development of practice and responses there. In terms of training, the National Implementation Action Plan Group have been asking the 32 local authorities about what is their training strategy, what is their strategy for FGM, do they have one, how robust is it, and actually what is the training that's delivered. And again, I would agree that I think single agency, we do have single agency training, we have child protection, multi-agency child protection, so at different levels for different areas of specialists and investigators there will be training, but it will be very different across the country, and that doesn't support us drive practice forward.
Okay, thank you. Okay. Okay. Mary.
Thank you, Convener, and good morning, panel. I wanted to look in a bit more detail at the actual practical impact of the protection order, because in response to previous questions, we've heard words like empowerment and it will protect women. In very practical terms, what will the protection order do for women and girls?
It will provide that layer of protection, in our opinion. I think by, and I think I said previously, by having that in place, what it will do, and I was asked this earlier about what is the difference between that and the existing legislation. The fact being that anybody can apply for the protection order as well, in terms of that responsibility, not necessarily being on the shoulders of a young victim or indeed a survivor, then we are, from a societal point of view, we are then saying that we want to protect you. So we are going to apply for this order, whether it be a local authority, police, or indeed another agency, in order to protect you. And in practical terms, in terms of whether it be imposing certain conditions on an individual, and not so much so the child protection side of things will take care of the child. If the child is at risk of significant harm, and as Liz said, we're then into child protection orders, CSOs and children's hearing system. But in terms of any potential perpetrator and preventing any activity or conduct being undertaken, then that's where we see that level of protection coming in.
Okay. Do any other panel members have any thoughts on the practical impact that the protection orders will have?
I agree with what Elaine said. I think it does let us look at bringing perpetrators to justice, actually, and offering protection to children and young people and women as well. I think in terms of the practicalities, again, the parallel to forced marriage has been really important to think about actually what people's experiences have been of actually being protected by a different kind of order. So again, I think that's been fairly successful for specifically young people that I'm aware of.
Okay. I mean, we heard in some of the evidence that we've taken that people were unaware that FGM was currently against the law. We've heard people saying that particularly young girls would be unlikely to speak out against their families. So if there is a section of the population that doesn't know that currently FGM is against the law, and if you look at overall the FGM is not something that's openly talked about. It's kept something that's very much it happens, but we don't talk about it. If the protection orders come in and we have a section of the population that doesn't know it's against the law, that are reluctant to speak out against their family, how is the protection order going to help them?
I think it's quite similar to sexual abuse, isn't it? And Suzanne talked about what we're doing in the curriculum to work with children about actually understanding that your body, you have a right to not being abused. So I think if we look at sexual abuse, we look at the historic abuse inquiry just now, so many lessons learned there. It's not dissimilar to victims not being able, one, not recognising that sexual abuse is not okay and is against the law and is an abuse of them. So I think it's very similar to other forms of abuse.
Okay. Do any other panel members have any different views?
I think it's important that young people do know their rights, their sexual rights, and also legislation. I think that's why it's really important that it's in this new resource and also within the curriculum. There's a new document that's just been published as well about healthy relationships and the law around consent, because again our young people don't understand the law around consent. So it's a very similar argument in terms of making sure that our young people do know the law around that and actually what their rights are around consent and abuse.
Yeah.
Okay.
Just in terms of that rights aspect, this is where this falls in. So absolutely, we know that a lot of people don't understand that FGM is illegal. So it's our job to make sure that that understanding is out there, and that we link it into that rights, the protection of their rights, and indeed gender-based violence as a whole. So that's where we would, going back to the original discussion about universal awareness and publicising the fact that FGM is criminal, that it isn't a criminal offence, and that FGM protection orders would be there then to protect you, would go hand in hand with how we would see the information around about the bill rolling out.
Okay. Can I ask you now about the support that's available, that's currently available to support women and young girls and families that have had FGM or are likely to be removed to another country for FGM to be done? What current support is there, and do you think it's adequate? And do you think when the protection orders come into place that a different type of support should be put round families and young women and girls?
Again, that's a question that the National Implementation Action Plan group have been looking at, because it will be patchy across the country. And so actually, and we asked the same question when we were looking at the Child Sexual Exploitation National Action Plan about what support services were available to children, young people and their parents and carers. And again, we know that that's not consistent. So again, I guess the question that the national group is asking each of the local authorities is what do you have, and if you don't have anything, do you need to think about what could you put in place? What services do you have, or do you need to utilise existing services or think about the creation of other resources?
But before the rest of the panel come in then, can I ask you, and then if the rest of the panel could answer this as well, if you come across a young girl who is potentially at risk from FGM, what currently can you do to support her?
So from a Glasgow perspective, we have services that we would refer to. So we would refer to Sahelia, we would use them. So that's good for us in Glasgow, but I'm not sure what would happen in other places, but we would be able to access resources.
I mean, I accept it may be slightly more difficult for our education people on the panel to give an answer, but perhaps Elaine, what services do the police have at their disposal to help and support people that are at risk of FGM?
Very similar from a local authority point of view, and again I would echo what Liz is saying in terms of this patchwork of support that is available across the country for all aspects of child abuse. So that's where, that going back to the interagency referral discussion, what is out there, what is best, how can we support, and what actually does this child need, and that's putting the child then at the centre to say, well, what does the child need by way of support, and is that available? So the agencies that Liz spoke about very much are the ones that we would go to as well, but that would be done within that multi-agency setting, again just to see that we have the best support that is available, if it is available.
Okay. Can I ask the panel now about legal aid, because one of the things that we've heard is that legal aid should be free to anyone that needs support around FGM. What's your view on that? And I accept you may not have a detailed view, but do you think legal aid should be free?
Everybody's nodding.
Everybody's nodding.
Say why it wouldn't be.
Well, I mean, because what we've heard is that the usual criteria for application for legal aid will be applied for this. So a financial assessment will be done, and there may be some financial contribution required. But we have heard that legal aid should be completely free. Do you think it should be the usual criteria, or should it be completely free?
It's actually not something that I have considered, so I'm considering it on the spot just now. I think because of the evidence that you've heard so far in terms of underreporting and people not coming forward and not having faith in the system itself, and that's the whole system, I would certainly support an argument for it being free, because we are not, it is not like any other crime that we are seeing just now. There is a difference here because the people aren't confident in the system as a whole, or indeed, as you pointed out, don't even know that this is a criminal offence. So that would be my own opinion.
Okay. Do the rest of the panel agree or have any different thoughts on that? No? Okay, thank you.
Okay, Annie.
Thank you, Convener. Good morning, panel. We've heard a few times, especially from Elaine, about the underreporting of instances of FGM, and potentially that's led to no prosecutions being done in Scotland. I would just like to hear the panel's view about, should we introduce a duty to report? Should we make an offence for failure to protect? And the anonymity of the woman or girl. We've had quite strong support for anonymity for people that come forward. And it's just really to hear your views on those three aspects. That should we consider putting them in the face of the bill, or is it something that we can do through statutory guidance or whatever? Just to hear your response to that, please.
In terms of duty to notify, I think because we have already established child protection procedures, these conversations, that notification is taking place already in terms of when we feel that there is a risk to a child. So I think that is an existing framework. I think statutory guidance to clarify that will help. I mean, having been involved in the multi-agency guidance in terms of that when to have that IRD was certainly part of the discussions. With regard to agencies informing other agencies. So I think we already have a good, sound child protection process in place, which will be further strengthened by the revision of the National Guidance in Child Protection in Scotland. So I think we have these links in Scotland. In terms of the offence of failure to protect, I think we are then in danger potentially of, we're asking people to come forward, we're asking people to tell us, we're asking people to report, and then potentially saying, well, we've now gathered all of that evidence, thank you very much, but we feel that you've failed to protect. So there is a danger then of potentially driving the practice even further below the surface from what it is already. So that would be our concern in relation to that. That said, if there was clear and obvious evidence that somebody had, or a parent or a carer had overtly exposed a child to danger, then there is, the existing legislation in terms of Section 12. So that would be my response in terms of the failure to protect. And in terms of the anonymity, again, there is processes in place in the legal system in terms of protecting the anonymity of individuals. I don't know about the automatic right to anonymity because, again, it comes down to the individual who may want to have their details known. They may want to stand up in court and have their evidence heard, and they may wish to not remain anonymous. So again, it comes down to this being rights. So, if I think each case would then be dealt with individually and the appropriate measures, if need be, put in place. And the other legislation that's obviously coming into play in Scotland is the Vulnerable Witnesses Criminal Evidence Act, which can see the use of prior statement or evidence by commission. So that would be another option as well.
Does anyone else get anything to add? Because my other sort of a bit on this, and we've heard it's been touched on earlier, it's like some people might not feel that confident to report if they've never had to do that before. So again, it's maybe not the it's maybe some more guidance on how they go about doing it rather than making it on the face of the bill. But we need to make sure that people feel able to actually go forward to that relevant person. I don't know if that's, and I think it was maybe yourself, Susan, that maybe touched on that earlier, just about giving people the means to understand and to have that conversation in order to move on. Would that be something that we would probably look at?
Certainly teachers would always refer to the Child Protection Officer and wouldn't actually deal with this matter directly. And they know the children really well, so that system is well established. Yep.
That's fine, thank you very much.
I wonder, we heard some evidence previously about the potential damage to relationships between practitioners, and whilst obviously child protection is the most important things, that having a duty to report might actually cause, you know, potential harm. Do you have any view on that, or any sort of examples that would?
Yeah, I think I would agree with Elaine that I would not be in favour of the duty to report, and that we do have really robust child protection multi-agency processes and practice. And again, I think thinking about each case needs to be looked at individually. So in terms of criminalisation or failure to protect is a really delicate one. Frequently we are working with mothers who might not be aware, or they might be coerced, or they might be powerless in terms of being able to do anything. And again, I think that's an individual risk assessment and thinking about what our intervention and our ongoing work with that non-offending carer might be. So I think that's really important. I don't think we require a duty to report. I think it would be a detrimental practice, actually.
Okay. Andrea, did you want to?
I think that this is all about very, very careful professional judgment. It's about knowing children, observing them, observing their, you know, their habits, their behaviours and so on, talking to other professionals about what you observe, and that being in a climate of trust and openness. I think to introduce an element of legislation like that could create a kind of culture of fear, hypervigilance, and might actually result in you know, kind of counterproductive actions to what we're actually trying to achieve.
Okay, thank you. And on the anonymity point, can I just, for clarification, if it was in the bill and anonymity was there, would a woman or a girl be able to tell their story, if you like? Is that you said that it should be down to individual choice, and obviously we already have the capacity for anonymity. If it was on the face of the bill, would that prevent someone?
It could do if it was automatic anonymity. That was really my point, that it should be down to the individual to have that right, and make sure that there are measures in place, which there are, to protect if that is not what they're wishing, as opposed to it being decreed that you will be anonymous.
Thank you for that clarity. Oliver.
So just when you say that, do you mean that they should have an automatic right to request anonymity? Would you agree with that?
Choice in terms of requesting anonymity, as opposed to it being decreed that they would remain anonymous.
And do you think if they request anonymity, it should be automatically granted, or do you think that needs to be dealt with on an individual sort of case level?
I think if they request, depending on what that is and why that is, then absolutely that should be respected.
Thank you.
Okay. Does anyone else have any further? No? Okay, well, thank you very much for your evidence this morning. That was really helpful. We'll suspend now for about 5 minutes. And can I welcome our second panel this morning, Anne-Marie Hicks, National Procurator Fiscal for Domestic Abuse and Head of Victims and Witness Policy, Crown Office and Procurator Fiscal Services, Neil Hunter, Principal Reporter, Scottish Children's Reporter Administration, and Gillian Maudsley, Policy Executive, Law Society of Scotland. Good morning, you're all very welcome. Can I ask you to just spend a couple of minutes telling us about your experience and knowledge of FGM and the work you do in relation to it, and to touch on whether you support the bill's aim to strengthen the existing legal protections. Anne-Marie, I'll come to you first.
Thank you. The Crown Office and Procurator Fiscal Service does support the aims of the bill to strengthen the protections for women and girls at risk of female genital mutilation. In terms of our involvement, we have had involvement with multi-agency partnerships discussing guidance around this and involved in work around Equally Safe, where obviously FGM is recognised as a key factor in that. In terms of our approach, we have guidance for prosecutors in relation to the offences under the 2005 Act. We also have a national lead prosecutor who is a very experienced prosecutor in our National Sexual Crime Unit, who will be the lead prosecutor for female genital mutilation. To date, we have never received a case reported by the police in respect of those offences.
Thank you. Neil.
Good morning. We fully support the bill from the Children's Reporters Administration perspective. As you know, the hearing system is fairly unique in terms of care and protection of children and young people. It's a very broad, holistic approach to how we deal with children and young people in Scotland with significant longevity. The hearing system has adapted over time to a whole range of changing circumstances and societal challenges. And we very much see ourselves in the forefront of being able to adapt to a whole range of demands and changes on the work of the hearing system. We've got fairly limited exposure at this stage, I'd say, in terms of operational experience of FGM, and we have been continuing to brief our staff, make sure that they have a level of understanding and knowledge of female genital mutilation. We see it very clearly, as do others, as part of the spectrum of child abuse and exploitation. The hearing system was established to be able to deal with that in a very child-centred way. So we fully support the aims of the bill, and the hearing system, I think, will adapt as demands require.
Thank you. Gillian.
Good morning. Yes, the Law Society of Scotland is in full support of the provisions of the bill. Our involvement is on behalf of our members, in part, who both represent the Defence and the Procurator Fiscal Service, who will be involved in matters in connection with the terms of the bill. But it's not just about our membership. It's obviously in the much wider interest of the interests of the public and promoting and protecting the rule of law. And we see that the principles of the bill clearly do that. And the benefit, as we've said before, is of legislation that makes it abundantly clear to all parties what their responsibilities are. And to that extent, we certainly welcome the efforts being made by the Parliament to do exactly that. FGM is clearly an unacceptable practice. In my professional practice, I've not had any cause to come across it, but I'm certainly aware of the undercurrent, and the more that can be done, is clearly demonstrated by all the literature and support of the bill's provisions, is obviously of benefit to the public in Scotland as a whole.
Can I ask the panel if they have any reflections on why available approaches maybe aren't being used fully at the moment?
I think I'd fully support what the previous panel, I had the benefit of listening to them, have to say. I think there are lots of barriers to people reporting this, perhaps knowledge of the law, fear about it. I think perhaps levels of coercion, different power structures, you know, in community and people not being able to. So there's a whole lot of complex reasons why people can't come forward, but also challenges, I think, in gathering evidence, you know, even where something's made known to the police. So there is no doubt it is an area which is very challenging.
And how do you think the protection orders will assist with addressing
I think
that?
being able to act before something has happened is always a good thing. We've seen examples of that with other protection orders, forced marriage protection orders, but also things like domestic abuse interdicts, criminal and civil non-harassment orders and the like. So I think if you can have orders that enable people to seek help, or in fact not just the people who may be at risk, but also local authority, the police, to intervene when someone is at risk of harm, I think that's got to be a good thing in preventing behaviour before it starts.
Okay, thank you. Beatrice. Oh, sorry, were you wanting that?
Yeah, if you don't mind, convener, thank you. Can I just come in to ask a brief follow-up question to Gillian? And it's about some of the comments that were made in the Law Society's written submission. And I accept what you've said here this morning, but the written submission said we query exactly how the bill would be shown to be more effective in preventing FGM and safeguarding those at risk. And at the end of the quoted paragraph that we have here today, it says exactly why there have been no criminal prosecutions is a complex issue, but without that information, it's hard to illustrate its current effectiveness or otherwise at present, or provide a comparator. Do you have any further comments on that? Is that still the view, or is there a slight nuance to the view that you have?
I think that's still, we were really talking about an evidence base, and I suppose what we were trying to say in concern, it's not, we are fully supportive of measures being taken, there's no doubt about that, so that is not, if you like, any change. I think what we were trying to say is we're quite concerned about how these provisions would work, not that they wouldn't work, but how would you actually be able to show, I think what we were trying to highlight is your starting point and your future point, and if that helps by way of clarity. So in other words, by being aware that there's a problem at the moment, but as Anne-Marie has said, there's been no prosecutions. Now, that's a complex reason, and if you like, as well as your provisions of the bill, there's an opportunity to perhaps drill down, as you'll have heard in the first session, to exactly why that should be. So I think what we were concerned with is you bring in bills and legislation, you can show that they've been effective, but if you don't have a starting point, that can be hard sometimes to achieve. Does that help?
It does. Thank you very much.
Beatrice.
Morning, panel. We've heard why there's probably been no prosecutions in Scotland, but I wonder what your views are on the FGM protection order itself and what it might be able to do.
I think there was talk earlier on about empowerment, and I think that is really important. I think it's important that people can have their rights protected and it can prevent behaviour, but also it can also apply where an act has already happened and to protect people from further harm. So I think that's really important. I think we've seen examples in other legislation where a breach of a civil order is a criminal offence, and that can certainly strengthen the enforcement of that. So we see that with domestic abuse interdicts, non-harassment orders and the like. So, and also forced marriage protection orders. So I think that can have an additional protection for people.
Okay. Any other views on the panel?
I suppose having protection orders on the statute book offers an opportunity to both respond very quickly and effectively to issues of FGM as they arise, but also where there are concerns about a child's safety or vulnerability to FGM, allow, as Anne-Marie said, a kind of a preventative approach to be able to avoid the circumstances where a child is harmed or removed from the UK or any other form of potential risk that the child experiences. So there's both a reactive and a preventative element to the protection orders which we support.
Yes, I think the crucial word, as my colleagues have said, is the word prevent and reduce. It's not, I mean, clearly if people don't obey the orders, it's going to be a criminal offence, but the criminal sanction shouldn't come into play if there are ways of avoiding the problem starting. And I think I would really stress section 1 of the bill that says exactly that. It's there to prevent and reduce the likelihood. So before you get to actual commission of offences, you have protection orders that can come into place and protect those at risk. So I think that's very, very important.
Thank you.
Can I just press you a little bit on the empowerment aspect of it? I mean, obviously that's a good thing and a good word, but can you sort of give an example of how, for a mother and a child, the protection order will empower them? Because obviously it's something that's potentially being done to them. So it might be helpful for us to think of us and to have a scenario where, perhaps even using one that you know about now, where we don't have the legislation, where this protection order will empower them.
I think it gives people options. So it might give an individual an option. Now, someone might choose not to take that option, but they might wish to do so. And I think having knowledge of that and children also being aware of their rights would give people opportunities to have those conversations and to seek orders. I think it's also
sorry, I'm gonna interrupt and be a bit of a pest, but could you an opportunity for what? Could you think of something specific example?
So an opportunity to seek help. So if someone, say perhaps a young person thought they were at risk of FGM, perhaps there'd been discussions in the family, they were aware that they were to be taken out of the country. I have dealt with some forced marriage protection order issues, and having knowledge of that and being the ability to have an order would mean that people can contact. Sometimes that's a support agency, so it's not necessarily the police or local authority. Often it will be one of the stakeholder organisations, whether that's the Helia or one of the other agencies, who will then themselves be able to get involved and make an order. So it's having that framework, I think, where there is knowledge that there is a right there, that you don't have to do that, but also that you can then ask for help, and that someone, either yourself or someone on your behalf, can actually get that protection for you. I accept, as with reporting of criminal offences, not everyone would wish to do that, but I think it's important that there are a suite of measures available to people. I also think it's important sometimes that when people are at risk of harm, that the state does have to intervene to protect people. So I think it's really important as well that orders are not, the responsibility for seeking orders is not all put down to the individual. There can be financial constraints, there can be other constraints on them, and I think sometimes it is really appropriate for the police or local authority or others to intervene where someone's at risk of harm.
Yeah, okay, thank you. Oliver had a supplement.
Yes, thank you, Convener. Just on that specific point in terms of the balance between the sort of individual and other agencies, my understanding is the bill is currently drafted means that maybe someone with parental rights would have to go to the court to get permission to seek an order before they actually could, whereas the police and social work would have an automatic right. Do you think that's the right balance, or do you think that those with parental responsibility should have an automatic right to seek an order?
I think Section 5C of the Act lists a number of parties who can go, whether or not parents should have, automatic right. I don't think that's really something that we can comment on, but I think there are a number of parties, including the person who is at risk of harm, who can make that application, and including a parent as well. So I think from my reading, it was certainly provided an adequate range of provision there for all who might need to apply, to be able to apply to the court for such an order.
But just specifically on empowerment, if you're the mother, perhaps of a child or even a father, and you see that they're at risk, do you think that there is a disparity that you would have to seek permission from the court before you could go ahead? Because I think it's unlikely in a lot of cases, particularly for younger children, that they might feel able to do that without the support from a parent.
It's not really a matter for me to comment on that. I don't think it's, I mean, that would be a matter for yourselves as to whether you wanted to change that provision. But I think it's important that any other person is allowed to apply. I suspect the reason it's been drafted like that is that you could have a person who's not a parent applying, and so you wouldn't want necessarily to have another person in the neighbourhood who could simply apply, so I would imagine it's probably like that, simply to allow the court to have some scrutiny over who was applying for an order, as opposed to trying to prevent someone who had a legitimate interest. And I would have thought someone who was a parent who was applying from a protection of risk and trying to care for someone, I wouldn't foresee any difficulty with the court envisaging that they had a legitimate interest to become involved. I hope that.
Yeah, that's really helpful to me. Thank you.
Did you want to say something on that, Neil?
I suppose that, just in terms of that extra step, does help us ensure the legitimacy of the applicant and the applicant's relationship to the child, young person or adult, and does make sure that you know the court's able to assess the appropriateness of that application. So the balance seemed right to me.
We did hear some evidence, forgive me, I can't remember if it was last week or the week before, that actually abusive husbands may use, there was a potential risk that as part of their coercion they would claim that the child was at risk of FGM from the mother. Is that something you would consider where that extra step was needed, as you say, to ensure legitimacy?
I could envisage that could be, you know, something that would be done as part of an abusive process. But yes, I think it would be a matter for the court to look at all the circumstances then.
Okay, thank you, Oliver.
Thank you, Convener. In terms of my main line of questioning, I'm interested in two things. The first one being whether you think that the children's hearing system should be able to grant an FGM protection order.
I think in our evidence we've said that we don't see that as necessary. We have a broad range of grounds of referral to the children's hearing system that are cover a range of issues and difficulties that come up in children's and young people's lives. We're not seeking additional powers within the hearing system. We believe the current grounds of referral are sufficient and broad and importantly holistic in terms of the approach we have to children and young people. Neither are we seeking any additional powers for the children's reporter in relation to protection orders. We believe that one of the strengths of the hearing system is its focus on the child and young person, their best interests, their welfare, the paramountcy of their welfare, and the ability of the hearing to make a compulsory supervision order, which can regulate who has contact with the child, where the child resides, and also additional conditions that the hearing may deem appropriate in individual circumstances. So we believe that we have most of the powers that we require at this stage to be able to respond to FGM. We also have routes into the hearing system to the reporter from the courts, as outlined in the bill. We have, importantly and uniquely, a single source of referral to the children's reporter that allow anyone to contact the children's reporter who's got a concern about the welfare and protection of a child or young person, and we would then have a duty to assess and investigate very strong links with local authorities in relation to emergency protections for children and young people, and very strong links obviously to the police, who remain by far the majority referrer to the reporter.
And the Law Society of Scotland, I think it's supported in your submission.
This is very much on, in responding to the submission, it was both on behalf of criminal and family law, and just from the family law perspective, there had been a suggestion that there should be an additional ground of referral, and obviously about to Neil with his knowledge of the children's hearing system, but the feeling, just to quote from what the reasons for this feeling from the Family Law Committee was, it would ensure that a child enjoys the same procedural safeguards and protections that an equivalent person would have in a similar situation where the risk or welfare concern was other than FGM. It would avoid the possibility of important decision being made for a child already within the children's hearing system, but being made out with that system, and therefore it would be part of a whole system approach. It would also prevent the prospect of a child being made the subject of conflicting orders or measures. It would ensure that the threshold for intervention are consistent with those that exist specifically in other grounds for intervention at present. And finally, they would place an additional responsibility on the various stakeholders to specifically assess and identify children in need as to whether they were at risk of FGM. And clearly I support any thing in relation to the children's hearing system as being representing a specialism in this particular field of law. And I'm happy to let you have these further comments in writing, which were provided post our submission for the committee's evidence, if that would be helpful for your purposes.
I think that would be helpful, yeah. And in terms of the Crown Office, does the Crown Office have any view on this matter, or no?
No.
You think you'd be happy whatever Parliament decided?
I just don't think we have the expertise to comment on what happens at the children's hearing system, so I would choose not to.
Okay, no, that's helpful. And then my second set of questions were just round the criminalisation of a breach of an FGM order, and whether you think that that's appropriate, and if you do, what the penalty should be for a breach.
I think criminalisation is appropriate, and as I said earlier, we've seen examples of that with other legislation, other civil orders like forced marriage protection orders and domestic abuse interdicts. I think the offences that we have here go further than the legislation in England and Wales, so it's not just criminalising the person who breaches the order applies to them. So the approach here in Section 5N is to have 3 other offences for another person who's not themselves subject to the order. I think that's fairly novel, because usually the approach would be to criminalise someone for not following the terms of an order that they are subject to, whether that's a bail order, a non-harassment order or whatever. I think the comment that we raised in our submission was there will potentially be evidential challenges with that, because you would have to prove that the person knew what the terms of that order were, and that they have then breached it, which is obviously far easier if you are the person who's subject to the order and it's served upon you. So I think it could be evidentially challenging, but it would really depend on the circumstances of the individual case. In terms of penalties, it would be a matter for the court. I note the English and Wales offence has a 5-year penalty, so same penalties. Forced marriage protection order has a 2-year penalty on indictment, although that offence was introduced 8 years ago or so. So perhaps things have simply moved on, and it may make sense to have similar penalties to that in the rest of the UK, but it's just an observation, and sentencing would be a matter not for CLPFS but for the courts.
And in terms of gathering that evidence, do you think that there's an issue, I guess going back to the lack of prosecutions, where by putting things in law that we're not going to be able to prosecute or pursue, that we kind of undermine confidence in the legislation? Do you think that that's a legitimate concern, or do you think it's more important to send out the message that we think that that's wrong?
I don't know that it would undermine the legislation. I think the first offence, certainly against the person who's subject to the order, I think that's really important. Whether Parliament chooses to legislate further to include other people who are not themselves subject to the order but who maybe act to assist that person or to do the act that the person is prohibited from, I suppose is a consideration for yourselves as to whether to take that further step. But I do think it would be really important for enforceability that at the very least it is a criminal offence to breach an order that you are required to obey by the court.
Okay, thank you.
Okay, Mary.
Thank you, Convener, and good morning, panel. I wonder if the panel members could talk a bit about the support that's currently available to women, young girls that are at risk of FGM, and whether or not you think that support is adequate once the protection orders are in place. And if that support isn't adequate, what else do you think needs to be put in place to make sure that women, young girls and indeed families are adequately supported?
I think probably the parties who were here earlier are better placed to talk about that, because they will be dealing with people at a far earlier stage, and obviously by the time it comes to my office, that work has already started. I know there are a number of organisations, a number of stakeholder groups like Sahelia, like others, and even groups, for instance, the Scottish Women's Aid and the children's charities, Bernardo's, NSPCC and the like, will get involved in this kind of work. I think it's really important that that's there. I also think the points made earlier about education are really critical, and I think if you're going to have a law that's effective, I think it's really important that people within communities who are likely to be affected know about it, but also that children know about it and know how to access their rights about that.
Do you think, just before I bring you in, Neil, do you think within the court system, the victim support service within the court system should do something differently, or perhaps broaden the scope of their support services if we are in a potential scenario where cases will be going through court? Should they be doing something different?
So at the moment, Victim Support Scotland would deal with victims of a crime. So if someone was going through the court in respect of a civil protection order, they wouldn't be referred, to them in respect of that. So I don't think that would be their role, unless perhaps we were prosecuting a breach and someone was going through the court, in which case those measures would already kick in. I think it's important that there are good measures in court, and also proper support measures for people if to give evidence. But I think there's also really critical that there is that support in the community before it gets to the stage of court proceedings as well.
Okay, thank you. Neil?
I suppose what I want to emphasise is that a child or young person coming through the hearing system who is at risk of FGM, there are elements of the system that are hardwired in terms of the duties placed on local authorities to support and direct and provide services to children and young people and their families as part of a compulsory supervision order. So they seem to me to be pretty robust and pretty well established. There's probably a need for a balance in each part of the country between local specialist services that have a role in providing ongoing intensive therapeutic support to children, young people and adults who have experienced FGM or who are at risk of FGM. And also, I suppose, the area that I'm particularly interested in is kind of non-specialist universal services who have a role in understanding and being very clear and have a higher level of awareness of FGM issues to allow them to support children, young people and adults in these circumstances. They also have a very clear role in terms of detection, prevention and identification of needs and issues and risks. But there's probably something across the whole workforce that needs to be accelerated in terms of ongoing professional learning, development, so that regardless of where a child, young person or adult at risk of FGM is getting support from, that they'll be able to have a degree of support and guidance that's competent and confident to meet their individual needs.
Yeah, and when you talk about that balance in services, is your concern that there's almost a kind of postcode lottery around the services because of the very nature of the geography of the country?
I was going to say I don't have a clear enough picture across the 32 local authority areas in Scotland. I suspect in some of the big urban centres there'll be a provision of services, both specialist and more generic, and that you would expect that to happen. I think as time progresses and as we focus in wider awareness and workforce development, some of that can be evened out.
Okay, that's helpful. Thank you. Gillian, do you have a view?
Much has been said, but I would also refer that this has very much been one of the main thrusts of our response at all points, that we highlighted the role of education and training, which is absolutely essential. On the assumption that the bill progresses successfully, there's no point in having a bill unless people are aware and the provisions are there, and we've obviously said that on a number of occasions before. And that's got to be, as Anne-Marie has referred to this, where I'm aware of a number of specialist stakeholders, but that level of awareness and support is right across all these specialist services. The NHS, schools need to be aware of these provisions to try and support the people that are most at risk, particularly in the light of what we said in the answer to the first one, which is the lack of evidence base, which is not a criticism, it's a statement of fact. I very much endorse what you yourself have referred to, which is postcode lottery, because I do think it will be piecemeal, and where there are pockets that FGM or communities that this may be more likely, obviously are areas for specific targeting and resourcing things like libraries, help groups, etc., all seem very important. But fundamentally, to get the message out would involve education and training. And that includes, and I accept that, the legal professionals who may become involved in these matters to be, and the judiciary, of being aware of what their powers and exactly how prevalent, because it's under the surface. People need to be aware that it's there. It's just not coming up to prosecution level to see convictions to make it more apparent. And that's obviously a difficulty for us all where we have a role.
Okay, that's very helpful. Thank you. Can I come on now to ask you about legal aid? Because one of the things that come out when we've been taking evidence is that legal aid should be free for anyone that's at risk of FGM. And on the one hand, the consultation says that legal aid, the usual criteria would apply to legal aid, so a financial assessment would be done, and even if legal aid was granted, a small financial contribution may be required. But there is a view that it should be completely free. What is your view?
Probably me, I think. Wearing my other hat. Yeah. Well, I think legal aid should certainly be available for advice and assistance. I think the question of whether it's free opens, obviously, it can open gates to, well, if this is free, something else would be free. If we look at the spirit of access to justice, which is maybe the easier context, then I can see arguments in support of making it free, because if you're trying to encourage people to get advice and assistance, then you want to make sure that they're not being hindered by burden of financial assessment. But I, on the other hand, have to recognise the requirements of the state, which you start making certain areas exempt, there will be calls for other ones. So I don't know how large the problem is, because again, we don't quite know how much there'd be a call. But as well as making legal aid available, there needs to be lawyers to provide that legal aid to ensure access to justice wherever in the country that advice and assistance may be helped, and I would stress, and may be required. So I would stress that aspect as well.
Can I ask before Anne-Marie, you come in, because we've talked a lot about forced marriage and forced marriage legislation. Is someone entitled to legal aid, free legal aid, or is it the usual criteria that applies if they're going through the court around forced marriage?
I'm not sure either. I would have to check. But if the committee would like me to come back, I can go through the legal aid committee and check the point out if that's what you'd like us to clarify.
I think that would be helpful, because we have talked a lot about. And FGM is not the same as forced marriage, but there are similarities around the fact that it's something that's underground, it's not talked about, and we need to encourage more people to come forward. So if you could provide some information around the forced marriage, that I think would be helpful.
I'll be happy to do so.
Thank you. Anne-Marie, do you have any view on legal aid?
I think, as Gillian said, there are various considerations. I don't think it would be appropriate for the Crown to review on that.
That's fine. Neil?
I suppose the only thing I would say is that if agencies and local authorities and others are not making the application for a protection order on behalf of individuals, then I think probably the likelihood is that the circumstances that individuals find themselves in require really rapid access to legal advice and assistance. So that suggests to me that if there were barriers or inhibitors in access to legal aid, we need to examine those and try and reduce them. I would imagine that the degree of urgency around an individual seeking to make an application to protect themselves through an order would require pretty rapid access to legal advice and assistance. It does also, I think, talk to Gillian's earlier point about the need for everyone to have a level of awareness and understanding to be able to enact our public protections rapidly and effectively.
Yeah, and I suppose whatever guidance goes with the bill, the strength of that guidance to be able to point people in the right direction, whether it's legal aid, support services or anything else, everything has to join up and be reflected in the guidance and information that comes with this piece of legislation.
Yeah, just to pick up on your point there, I think that it is that finding and signposting of information, be it support, be it legal advice, and I think that is crucial, and that obviously reflects into other areas that the Parliament has been looking at, how to signpost people to legal and practical assistance, and also ensuring that that signposting service is available no matter where in the country, in Scotland, that person who's at risk may be. So I very much would welcome that kind of strength, and very much the guidance I do think is extremely important, because that is exactly where is on the book for people to go and look, and very much would welcome that.
Okay, that's helpful, thank you.
Annie.
Thank you, Convener. Good morning, panel. In the submissions that we've got with regards to anonymity of victims and failure to protect and duty to notify, there is some sort of there's various responses there. I think the question on anonymity would be, should it be automatic anonymity if a woman or girl comes forward to report FGM, or should it be that it goes through the sheriff as it does at the moment to get those special measures put in place? And also failure to protect. We've said, and I think it was all the side of Scotland said that's something that could be looked at after if the bill was passed. And also just to notify the police. We heard from Detective Superintendent Galbraith in the previous one that there's already methods there to allow that to happen. So it was really just to get your views on those aspects, which obviously are in the legislation of the rest of the UK, but not here, and to see what your views are on that, please.
I have to go first. I think in terms of anonymity, there are already provisions in place at common law and under statute to address the issue of anonymity across the board in cases, and I think they would be adequate in terms of addressing this for FGM cases. Whether or not you wanted to go further and to make that across the board in these cases, and as has been discussed, I suppose is a policy choice. The only observation I would make is that there are perhaps lots of other cases where there isn't that automatic anonymity, perhaps in sexual abuse, exploitation, or even other non-sexual cases involving exploitation that perhaps would also seek such a thing. But from a practical point of view, there are already a number of measures that can be employed and would in such a case where that was appropriate to do so. Sorry, in terms of the failure to protect, again, I think that's a fairly novel aspect. Interestingly, I was at an event yesterday where a senior social worker was talking about, I suppose, some of the negative legacy of the failure to protect approach which social work adopted in relation to domestic abuse, which had the effect of effectively blaming women who were mothers who were victims of domestic abuse for exposing their children, and talking about how that had the effect of stopping people from reporting to the police and also seeking the help they needed from social work. I think that's got to be a concern here. From my perspective, there is a law already in terms of Section 12 of the Children and Young Persons Scotland Act 1937, which would allow us, where the circumstances were appropriate, to prosecute someone for willfully neglecting or exposing a child to harm. So I think there's already provision there in place that perhaps wouldn't have the unintended consequences of a specific offence. And last, in terms of the duty to notify, we are not particularly involved in that. I listened to what the police and social work said earlier, and that seemed sensible in terms of the established procedures that they already have in terms of child protection, but I don't have anything further to offer in terms of that.
Thank you very much. Anyone else? Gillian, yourself?
On the anonymity, the Law Society did come out in balance, and I think we remain in balance, supportive of provisions. I take much of Anne-Marie's point that there may well be adequate protections there, but we did highlight, I think, both in our consultation response and in our response with regard to the call for evidence, that there might be circumstances that the press would try it out. I suppose our feeling was, and it touches on something you talked about earlier about the need of vulnerable witnesses and support, is that although we don't want unnecessary legislation, and I'll touch on that secondly, this was perhaps an opportunity for this bill to carry that very specific measure. As I say, I'm not saying that there isn't adequate there, but on the face of the bill, you'd be very much underlining that anonymity is there and there for these people. Now, whether or not other bills or other areas of crime should have that is a matter for a separate time and a separate place. But you're looking, I think, as I understand it, for things that could actively be done for what is an undercurrent of a problem. And I just think making it abundantly clear, it's back to our point also about clarity of legislation. Make it clear, this is what you're saying. There can be no doubt. It's not left to a sheriff, perhaps, and the press don't go and try something out or make a mistake. So I suppose anonymity was the one that we could see from the English setup. Why not, I suppose. With regard to the others, I would really refer back to what I said in the call of evidence. I mean, failure to protect, whether there's adequate protections or not, my concern is always, or our concern as a criminal law committee, is over-criminalisation of the law, making it too complex or too many offences, and the police don't know what to report, and it's difficult to prosecute. So I was really kind of, if you like, hedging bets that if you were to find that after the bill was there that there was some need for it, then clearly you could look at it again when you had some evidence base. I don't really have anything to add to duty to notify to the police, but obviously if there's always to be a positive duty, it must be contained in statute. I'm always concerned that, you know, that you set out all these duties, and sometimes that could be best left to guidance. I don't think there's any more I could add.
Thank you very much. And Neil, anything from yourself?
In relation to children and young people, I think we operate in a very strong presumption of anonymity in any case, and certainly within the hearing system it offers stringent protections in relation to transmission or reporting of any proceedings or in any information in relation to a child or young person within the hearing system. I think anonymity in a broader sense is going to be really important in this context. I think, again, we might work in some presumption that anonymity will be offered to people coming forward and making representation, making application. I suppose I agree with my colleagues in relation to the whole issue around failure to protect. I think it's a really complex area. We, again, in relation to children and young people, where there is demonstrable willful neglect or harm exercised on a child, then that would be a criminal offence. In relation to this area, I think it's much more complex because there's lots of power differentials at play within families and within relationships. I think it's I see the potential benefit in terms of a broader duty on people to protect and report where they can. But there is a degree of complexity in relation to power and exploitation and oppression that is placed on people, which make, I think, it more complex in the way that Anne-Marie suggested.
I think that answers my questions very well. Thank you very much.
Okay, thank you. Our colleague Fulton had to appear at another committee, so he had some questions around training. So I suppose just to hear from yourselves, you know, what training currently happens specifically around FGM for the people that you're here speaking on behalf of, and if there's any gaps. And
I think from the Crown Office we have guidance in place, and also have regard to the multi-agency guidance that is there, because we've not had to deal with any cases. It's not a major area of training for us, but we would, for any bill that's passed that creates new offence, we will likewise create new resources for prosecutors, and if there was any further training need developed on top of that, then we would address that.
As you may expect, we do a lot of work with our children reporters in relation to child sexual abuse, child sexual exploitation. FGM fits within that whole continuum of children who are vulnerable and at risk. We haven't done a huge amount in relation to FGM specifically, but we, I think, are at the stage where we have degree of confidence in terms of our own workforce about awareness and visibility of this particular issue. I think there's probably something compelling about a wider workforce plan around FGM. Again, I've touched on the issues around how important universal services are in relation to health, education services and others. Doing that alongside, I think there's real potential in terms of a workforce development approach that has interagency, interprofessional training at its heart, so that people are able to learn from each other's roles and responsibilities.
Thank you. Can I ask, another issue that had been raised with us was the sort of potential for racialisation of this issue. Do you have training on that side of things? Because I suppose that cuts across, even if you're not dealing specifically with FGM at the moment. There's a more general point there.
I think a broader approach has been to look at child abuse, child exploitation, child-related harms as a kind of broad, generic approach, rather than focusing on particular groups in the community or particular subsections of the community. We're well aware that abuse and exploitation of children and young people happens across the community, so that our broad awareness of the issues is really important. I think a couple of in previous evidence we've given to committee, we focused on some of the research work we've done in relation to black and minority ethnic communities and in relation to child protection procedures, and we identified a real need to understand and raise awareness amongst the wider workforce of some of the fears and anxieties that people within those communities have around child protection procedures, to be able to close some of that gap. So we're both taking a very broad approach to development and training and awareness, but also understanding that particular areas of the community have worries and concerns about child protection and child care issues.
I suppose I'm asking about the racial biases that we'll all have. Is there a focus on that in training at all?
To some extent, there's always an emphasis on training around bias and misunderstanding and prejudice. So to that extent, yes.
Okay. Does anyone else have any?
Well, just in training, again, there haven't been any criminal prosecutions for defence solicitors as such, but they would be aware of their responsibilities as they would in any defence case. It's probably not about specialist training whatsoever, but I also highlighted, obviously, Crown Officer, also our members, and Anne-Marie's already dealt with the Crown Office side, but I also identify in-house lawyers who may work for organisations that are the ones that may have to produce guidance, etc., for their staff. So, again, there may be involvement of solicitors in legal responsibilities. And picking up your point about racialisation, clearly equality and diversity is a key part of much of legal training, both university and otherwise, and within any office or organisation. So I think to a large extent that is the area in which specifically it will be covered, because people are certainly, that is very much a part of training that is followed all the way through legal careers.
I would mirror that. The Crown Office have invested over a number of years significantly in training around diversity and equality issues. It's a big commitment that we have around that. We've also had training for our staff, for instance, around things like unconscious bias and things. I think any case reported to us by the police, we would be looking at the facts and the evidence, and also have regard to any available guidance on that. So I'd be quite confident that that would be able to be dealt with in an appropriate way.
Okay. Is everyone content? Okay, well, thank you very much for your evidence this morning. That's been very helpful. Our next meeting is on the 31st of October, and details and an agenda will be available on our website on the 25th of October. We now move into private session.